time to talk about the ATF's rule concerning the definition of frames and receivers. We're going to talk about what we know, what we think we know, and maybe some misconceptions that are rolling around out there. I heard about the dates from Guns and Gadgets on YouTube. DOJ added an effective date of June 2022, and we expected to have 90 days after that until it got force of law. More recent reports are saying they've moved that up to April, and they expect it to have force of law 60 days later, which kind of lines up with the original June date, because 60 days after April would put us in June. The first, most important, most terrifying thing I want to talk about is that the proposed rule we all commented on in 2021 isn't necessarily the rule they're going to roll out as the final. I'm guessing by now someone at the DOJ realized that some of their examples, specifically images like this, a 320 FCU going into an old P-80 Spectre, don't make any sense. Now, we don't know that this rule will be the end of private gun making as we know it for forever, but we do know that that is what the government's goal is. At the very minimum, we should anticipate a small interruption, a period where you can't acquire some or all of the components to manufacture your own firearm at home. I always be stocking up, and if you can afford to, yes, it is a good time to buy as if we may never have the opportunity again. Because while I believe it's unconstitutional, downright illegal for the ATF to usurp the power vested in Congress to write legislation, rather to override legislation passed by Congress, I don't think this administration cares what's legal or illegal. And while Gun Owners of America, and I'm certain other organizations like theirs, have various iterations of litigation ready to go to court, to file, to start fighting for us as soon as this rule is actually published, if the correct result occurs, that our constitutional rights win in court, we have no idea how long that will take or whether we'll have access to the things we love during that litigation. Now let's talk about some of the misconceptions or myths that are floating around based on some folks' interpretation of the proposed rule. Before we do that, I want to underline that the final rule isn't necessarily going to be identical to the proposed rule. So whatever we think we know from digesting that proposed rule isn't necessarily what the final one's going to be. I've read more than a few places someone saying they believe that all existing designs are grandfathered in because there is a section in the proposed rule that discusses this new rule not being meant to override ATF's previous determination on existing models such as Glocks. Now again, even if that proposed rule was what the final rule was going to be, that only applies to firearms that have existing ATF determinations that they are a firearm. Remember, the Polymer 80 does have an ATF determination letter that their original product is not a firearm, but that's a determination that it is not a firearm. And if you read through and really analyze that proposed rule, it says their determination of what is the frame or receiver of existing firearm designs. And since what they determined on something like the P-80 was that it was not a firearm, technically they didn't spell out that that would continue to be honored. Another interpretation that's floating around from the proposed rule, which again isn't necessarily the final rule, is that the rule says that all upper receivers and slides all have to be serialized. What the proposed rule does is empower the ATF to determine which parts or parts of a firearm design are the frame or receivers. So yes, under that proposed rule, they would be able to decide if they wanted to classify an AR-15 upper receiver or a Glock slide as a frame or receiver. But the proposed rule in and of itself doesn't classify those things as receivers. And that brings me to hopefully my final point, what I believe is the greatest danger to our constitutional rights, the most egregious overstepping of the ATF's authority. The section that discusses things like readily convertible and the way or the measurements, the criteria the ATF is going to be allowed to use to determine if any object is a firearm frame or receiver. Not only are they ambiguous, as in they say how long it takes, how expensive it is, what type of skills are necessary, without drawing any clear lines about what constitutes highly skilled, what constitutes too long, what constitutes too expensive. It vests all the power to use those ambiguous criteria and decide what is or isn't a firearm in one unelected bureaucrat, the director of the ATF. So one person, not chosen by we the people, would decide how you and I are allowed, are permitted to exercise our constitutional rights. So what can we do? I don't tell anyone else how to live their life. That's what freedom means to me. I can tell you what I'm going to do. I'm going to put a couple more on the shelf. And if you're going to do that, if you start at pewtang.com, any link you use to order something does help us out. I'm going to renew my GOA membership and drop an extra donation in there. Not that there aren't other organizations preparing to and are going to fight this for us, but I know people directly involved and other people I trust that trust in GOA. And I'm going to contact my legislators. I've added a button on the homepage at pewtang.com that goes directly to GOA's legislator lookup so that you can find and contact yours if you'd like to. I'm going to very simply and plainly articulate to my legislators that I need them to do whatever is in their power to stop the ATF and the DOJ and this administration from usurping the power vested in them to write law when we the people voted for them. I think that's all I got rolling around in my brain right now about this one, guys. Thank you, as always, for being here with me. Thank you for being in this fight, and stay free. Take care.